After more than half a decade of waiting, justice finally served in the Brooks Sandwich House murder. The two men accused of killing one of the owners now facing life in prison without the possibility of parole.
A jury found Terry Connor Jr. and Stephen Staples guilty in the 2019 murder of Scott Brooks. Charges include first-degree murder based on lying in wait, kidnapping, and robbery with a dangerous weapon. Scott Brooks was shot and killed while opening his restaurant in December of 2019.
All right, joining us now, our chief of analyst, Khalif Rhodes. Khalif, we want to start with this lying in wait. That was confusing to some people there, saying that they were waiting on Scott Brooks there. So that shows what, premeditation? Can you break that charge for us?
It does, and so the charge is murder. And so this is ironic that this comes up. My last homicide trial that I was involved with, that was one of the theories that they were attempting to go with as well. And so you start with the original charge, then you go to trial, and at some point you're trying to paint a picture of how these individuals committed this crime, and then there's something called a jury conference or jury instruction conference between the attorneys and the judge, and we're trying to figure out what jury instructions we want. There may be a jury instruction for first-degree murder, premeditated, and deliberation. There may be one for felony murder, but then there's also one in North Carolina for lying in wait. Well, for you to be able to argue that that jury instruction should come in, you have to have presented evidence in the case that this individual or these individuals lied in wait at some point. If there was no evidence submitted, the defense attorney will say, well, Your Honor, the record didn't have anything in their case in chief, and because of that, that instruction shouldn't be given to the jury. So once you can get that instruction in, then yes, the jury then has to make that determination if we can agree that they were guilty or not guilty on that. And so lying in wait, yes, it does need to be some hiding, some ambushing, some waiting. Most of the cases that folks will point to when attempting to argue for or against is they were at night, they were covering themselves, they were hiding behind a tree, they were hiding in a crowd. That's what, I mean, that was the point of emphasis. In our case, we were able to keep it out, but in this case, they were able to get it in.
So now that they've been convicted, when you have the lying in wait, when you look at the intent, does that change when it comes to the severity of the sentencing?
No, this
come
case,
down, or that will stay the same?
Yeah, in North Carolina, we are a death penalty case, and so at the very beginning of a case, the state has to make a determination if they're going to seek the death penalty. It's called a Rule 24 hearing. They announce it in court. Yes, we're seeking it, or no, we're not. If they seek the death penalty, it triggers a whole lot of things. If they don't, it's a typical case like this. Nothing typical about a homicide case, but it's just a standard homicide case, not a capital case. But the maximum, the only punishment, there's no deviation, there's no upward departure or downward departure. If convicted of first-degree murder, it is life without parole in North Carolina. There's no coming out, there's no chance.
And I think a lot of people, so this happened back in 2019, and many question, we talk about how slow the legal system moves, right? Can you explain and remind people why it takes so much time, especially in a case like this where someone's like, why did this take 6 years?
Mecklenburg County, the largest county in terms of the amount of cases that we have in the state. Wake would probably be number 2 behind us. I mean, we're back and forth. It depends on the week, you know. So I would say the size of our county makes cases take a long time. The other portion is just the investigation. From the beginning of a case, I tell my clients 3 to 5 years from the moment you meet me to some type of resolution, either plea, dismissal, or a guilty or not guilty verdict at trial. But that time, a lot of stuff is happening. You're getting discovery. You're reviewing it with your client. It may take the DA's office 6 months, a year to get discovery to me. So then I have to go over with my client for 3 to 4 months so they can review it. And then there'll be a plea negotiation, and then there'll be a rejection or an acceptance. And once you get rejected of that plea offer, then what can happen is you can say, you know what, I don't want this to go to trial, or I want to go to trial. They'll place you on the trial calendar. And then the last thing I'll say is COVID. COVID stopped a lot of things from happening, and that was it.
Khalif, when we talk about that time frame there, how much do you worry in terms of witnesses? Because one of the things in this case, we didn't have a smoking gun.
Yep.
So you're relying on this witness testimony and details from the crime scene. But do you worry with 3 to 5 years, in this case 6 years, the clarity of recalling what happened?
Well, I touched on this a little bit yesterday. A smoking gun would be something called direct evidence. Most cases are found guilty on or not guilty on circumstantial evidence. And the judge is going to instruct you to not weigh those separately and weigh them the same. And so regardless of how you felt about not having a smoking gun, the smoking gun is oftentimes not found. It's found in movies, it's found in novels, it's found in law school examples, but in real world, it's circumstantial evidence. It's cell phone data that pointed you there. It's, you may have, drops of a hair follicle somewhere, so DNA. But something like smoking gun, like I watched you do it, more movies than real life.
All right, Khalif, appreciate that. Another topic coming up next hour. Thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.